You may have heard that Spotify has decided against the renewal of Meghan Markle's podcast Archetypes for another season. Or as some of the headlines put it, Meghan's Archetypes podcast dropped by Spotify. And many of you might be asking the question, well, didn't they have to commit to her a certain amount of money up front? And could she sue them for that? And many of you might be asking, well, did they not have the opportunity to sue her for not producing any content for the 9 months or so since it is that she produced the 12th episode? Well, for the short answer to those questions, you'll have to watch till the end of the video because I've got a bit more to say first. But apart from anything else, it seems that the media company representing Archewell has made an announcement to say that they have mutually agreed to part ways. So I suppose you can glean the short version from that in that they mutually agreed to part ways and are proud of the series that they've made together, according to what they said to New York Post. And Meghan is continuing to develop more content for the Archetypes audience on another platform, according to Archewell Productions spokeswoman speaking to the Wall Street Journal. So aside from the fact that they appear to have mutually parted ways, which in itself may be open to question, that just may be the public stance. What really may have happened, there might have been a number of discussions about the failure to produce content in the last 9 months, if indeed it was a requirement for her to do so, or maybe Spotify hadn't paid on time or enough or whatever. These are questions that anyone might ask. And the truth of it is probably only known to the parties and their legal representatives or media representatives. So I'm speaking very generally here, not saying that either of these things have happened. They are just potentials and possibilities. Because in any situation like this, where there are a number of different aspects to a contract that either party has to commit to, you will also find a number of different clauses within those contracts allowing them to do certain things, restricting them on others, and giving them what we generally refer to as get-out clauses. So, as I know that we have a fairly international audience, I'm going to go through a few general overview get-out clauses that either apply in the UK, the US, or both. Now, I'm not speaking generally about force majeure clauses, which are both used in the US and the UK, which are the general provisions to excuse a party from any liability for something beyond their control. Pandemics and natural disasters, wars, strikes, government restrictions, and all of these kind of things apply to those. But aside from force majeure, which came up a lot in the COVID lockdowns and so on and spawned lots of litigation, let's talk about clauses that may limit liability in the event that a party has not fulfilled or intends not to fulfill or indicates that they intend not to fulfill their obligations under the contract. Very generally, you have a limitation of liability clause, which can be drafted in any which way they like, as long as it meets the sufficiently certain and reasonable tests, depending on the jurisdiction. These are used both in the US and in the UK, and as the name suggests, they will limit the amount of liability claimable by either party by way of damages and protects one party against the other in the event that they, for example, don't meet certain targets. So in the event of producing a podcast, if you didn't produce enough material to forecast the upcoming episodes or the upcoming season, or there's not enough material within each of those episodes, or it wasn't of good enough quality, etc., then these can be limitation clauses to limit one party or the other against the amount of damages claimable at the exercise of that option by that party. Next, there might be what we refer to as a material or adverse change clause, or a material adverse effect clause. And again, these are used in both the US and the UK, and the name, as it suggests, allows one party or another to back out of a contract without any penalty if or when there is a significant, usually negative, change in the circumstances surrounding either party, and protects one party's liability for fulfilling its obligations if there's been such a material change, usually an adverse or negative adverse effect change in the circumstances. For example, if one party to a contract was suddenly indicted for a very serious offence, then that might be part of this as by way of a morality part of this clause to say that this is a material adverse change in circumstances and this party no longer wants to be associated with someone who has now been, let's say, charged with murder or manslaughter or something like that. And that would protect the other party and allow them to back out of a contract because of this material change in circumstances. More generally, we have indemnity clauses, and these again used both in the US and the UK in slightly different remits. But these provisions again protect one party against the other, ensuring that the other is liable for any losses and damages. The indemnity, i.e. a protection, indemnifying the other party, so promising that they will pick up the losses and the costs and the adverse effects in a given situation caused by the other party. So ensuring that the other party is going to be liable for losses, damages, all of which arise out of their failure to meet any obligations. There might be, and now this is more common in the US, although it can be drafted into UK law, but it's more commonly used in the US, is a termination for convenience, or at least so phrased. This is a relatively controversial term of a contract in that it protects one party if they believe that the other party is not going to fulfill their obligations or reach certain targets. It allows for the other party to just say, we quit, we're off, we are terminating the contract, either within immediate effect or within a certain amount of days, and potentially without reason. Merely citing a certain not reaching targets or not fulfilling obligations or something like that may give rise to this kind of clause being activated. Similarly, now this is more a case of the UK version, we would have what we would call an escape clause, which again allows a party to terminate under certain specific conditions and protects them if the other party fails to deliver. So, as the name suggests, allowing them to escape from the contract. Now, more generally, when it comes to punishing certain parties, we have what we call penalty clauses or liquidated damage clauses, and these apply both, again, in the US and the UK in different variations. But these, again, stipulate potentially an agreed amount of damages up front that one party will pay to the other in the event of a breach. Now, important to note that these are not usually termed to be a fine or a penalty in a sort of criminal sense, rather an agreed amount of contractual damages in the event that one party breaches contract and doesn't fulfill their obligations. Just another note on penalties, because this comes up a lot with parking charge notices, at least in England and Wales it does, because if a term is deemed to be a penalty, a pure penalty, which is disproportionate to the innocent party's legitimate interests in enforcing the other party's obligations under the contract, then it will be unenforceable in most cases. One case that this came to light quite prominently was the Beavis and Parking Eye case in 2015. More about that in other videos. But in the context with the rule against penalties, a liquidated damages clause will be enforceable so long as that the amount represents a genuine pre-estimate of loss that the innocent party will or will likely suffer in the event of said breach. But as I said, if this is excessive, then it's likely to go beyond compensation, beyond acting as a deterrent, considered a penalty, and therefore not enforceable. Similarly, suspension clauses will allow a party to escape a contract if the other fails to meet their obligations, so it will relieve the other party of their obligations. So in the event that only a certain amount has been paid up front, but then obligations have not been met, then it would excuse that party, at least depending on the way it's drafted, from further obligation under the contract, depending on what the term says and what the obligations were that that party was supposed to meet. So in the context of a podcast, not that this is with specific reference, I'm talking generally, if there were a number of podcasts agreed or certain lengths agreed, or certain number of seasons agreed, or quality agreed, and things like this, or even ratings, even number of views or listens rather with a podcast might be agreed. And if those targets are not met, then there may be a suspension clause within the contract, again, both in the UK and the US, to stipulate that one party can be relieved of their obligations. And similarly, contingency clauses and severability clauses all broadly cover the same ground. So any kind of contract may have one of a number of these things in place, allowing a party to terminate early, terminate for damages, terminate for no reason if there's one of these convenience clauses, if it's just at the option of the party to terminate the contract. But it really depends on what the contract says. And the parties will usually take legal advice. Not always, you understand, but usually will take legal advice. In the case of Meghan and her podcast, I would assume that they've taken robust legal advice, as would Spotify, and as should anybody who is entering a contract, particularly to the tune of £15 million or $20 million that this Spotify deal was signed for in 2020, that Meghan and Harry agreed to with Spotify. So that's an overall roundup of what they could potentially do within a contract and some of the terms that might be included within a contract. And so the short version is, yes, they very well can. But for the final reason as to why they could do this is parties can, of course, always agree at their own discretion to ignore what the contract says and just mutually agree to part ways for any one or a number or even no reason that they so choose. If they agree to walk away and leave it at that and put out a mutual and amicable statement, that's possibly what happened. And it may also be to avoid any potential damages, litigation, disputes, legal rows and battles and so on, which I very much doubt either party to any dispute like this really wants. Most parties want to walk away mutually, although some companies are notoriously litigious and will, to coin a phrase that I heard once, litigate everything. So be careful of those, because some companies are like that. Do some due diligence on the company that you want to go into business with. If you're going to sign a contract with one of these companies, then Google the company and check out how many cases they've been involved with before. If they've sued 15 people in the last 5 years for lots of different reasons of breach of contract, I would strongly urge you to instruct a lawyer to have a fairly watertight contract and not otherwise sign it. And so with that in mind, I hope you found that interesting overview. Please make sure you like the video and subscribe, because that tells YouTube you're interested in the content. If you hit the notification bell, that will always ping your phone every so often, annoying you with some and rewarding you with others that you actually want to watch. So please hit that and ignore the ones you don't want to watch, but do come back for the ones that will interest you. And if you want my personal thoughts on this situation, what do I think really happened? It might be a pure guess, but I can tell you what I think probably happened over on Black Belt Secrets, linked in the description below. I'll see you there.